Thank you very much to everybody who's given me such a warm welcome here. I'm privileged and grateful to be here to join this great conference. So far, we've had so many great ideas, and I want to thank you for including me in this, as our topic today is about inclusion. And as you've just heard, I'm the author of a couple of books which I've brought to show. The first of which is Economic Freedom and Social Justice, the classical ideal of equality in contexts of racial diversity. So I'm actually going to be talking about the classical ideal of equality, but I'm going to be explaining how that has been corrupted, as it were, by the socialists who are in charge of implementing equality. And I also have another book which extends those ideas to the debates about historical injustice. It's called Redressing Historical Injustice, because you often hear people saying, what about my historical grievances? So that's what I address in this book, together with my Mises colleague, David Gordon. So we heard earlier about the long walk through the institutions, the long march through the institutions of the Marxist scholars. And what I want to talk about this morning is about how that long march has walked through the legal institutions by small steps, twisting and turning the legal concepts. So the concepts are the same. So if you look at the legal framework, you think, oh, this is nice, this is equality, this is fairness, but the meaning of those concepts has been changed by this long march through the system. And some of you may be aware that critical race theory, critical theories, critical social justice, started in the law schools as critical legal theory. So by now, we have judges on the bench who are schooled in critical legal theory. And so when you say to them equality, you may think that you're only talking about equal opportunities or fairness, but what the judge is hearing is DEI. And so that's really the message that I want to put forward today. And I'm going to draw upon Murray Rothbard to suggest that we must reject egalitarianism altogether. There's no such thing as the good form of egalitarianism and the wicked form of egalitarianism. Egalitarianism is to be rejected altogether from the legal system. And again, this links to what we've heard from some papers earlier. This is not about private morality. You may think to yourself that you want to be an egalitarian because this is your preferred worldview. That's not what we're talking about here today. We're talking about the policy framework, the legal framework, which is enforced by coercion, and that is the system we're saying ought to reject egalitarianism altogether. As many of you will know, Murray Rothbard's view of liberty was different from Hayek's view of liberty. So Hayek conceptualized liberty as an absence of coercion. So what Hayek would say is, you can have your ideals if you want to, but you don't coerce people into following your moral ideals. And Murray Rothbard conceptualized this as a defense of private property, self-ownership and private property. You infringe upon people's rights of self-ownership when you try and force them to promote whatever egalitarian ideals you may think are good ideals. So that's essentially the message of my paper today. In the preface to his book, Socialism, Ludwig von Mises warns us of the threat posed by socialism to individual freedom. In particular, he says, we must be concerned with the desperate struggle of lovers of freedom, prosperity, and civilization against the rising tide of totalitarianism. So we are the lovers of freedom, prosperity, and civilization. And our concern is to see the threat posed by the rising tide of totalitarian barbarism Now, here's the thing about barbarians. If they marched saying, I'm a barbarian and I'm here to take over all your institutions, we would not have a problem. Everybody would say no. The problem we have is that they march under the banner of social justice. Some people were asking earlier, why is Marxism so successful? It's successful because it marches under the banner of ideals that people love. When you say social justice, ordinary people, they're not Marxists or socialists, but they want to promote justice. They think this is nice. This is why they are beguiled by this idea. And this is something that Friedrich Hayek was trying to argue against in his book Law, Legislation, and Liberty, in his second volume where he talks about the mirage of social justice. He says, social justice is an empty slogan. When people say social justice, you assume that you know what they mean. You assume that they're just talking about good things that we should do, be fair, be inclusive, be diverse. But it's an empty slogan, and Hayek says that it is used as a pretext to justify socialist policies. They call it social justice, but it's really socialism. And Hayek says that the reason they do this is so that they don't have to justify what they're proposing. And so they don't have to give reasons, because when you say this is for justice, this is for social justice, people don't ask you why. Why should we have social justice? It's a self-evidently good ideal, and Hayek says this is the reason why they call it social justice. But the idea of social justice is still viewed as morally compelling. To most people, they think it means moral fairness. Everybody wants to be fair. I've never heard anybody saying, I'm against fairness. So this is the problem. And one message that I have tried to put forward is that fairness is not synonymous with equality. So in the book that I was just showing you, I'm talking about the English common law framework, and the English common law framework is based on notions of reasonableness. So many legal concepts are based on a test of reasonableness. For example, just to give an example of the duty of care, have you shown the care that we would expect you to show in the circumstances? The test would be, what would the reasonable person do in the circumstances? So that's a test of reasonableness, and we may think of that as a test of fairness. Treat everybody fairly. This is not the same thing as equality. Equality in the legal system is based on comparison. You're not asking if people have been fair, you are comparing different groups and asking if the two groups have been treated the same. So if you treat your employees equally badly, you haven't violated the law because you haven't discriminated. So just to give you an example, when the equal pay claims were brought in England, as some of you may have been following the news about how equal pay bankrupted the city of Birmingham. But before that, there was a great equal pay claim in the BBC where the women broadcasters said, why are we paid less than the male broadcasters? And the BBC said, well, it's because the male broadcasters bring in a bigger audience. That's why we pay them more. And the women said that's not allowed as an excuse under the equal pay legislation. So they sued them for violation of the equal pay rules. And how did the BBC resolve this? By cutting the pay of their male broadcasters. They cut the pay so that they could say, we're now paying everybody equal. So some of the male broadcasters were angry. One or two of them were angry. They said, this isn't fair. But most of them, because they're good liberals, they said, well, I want to do my bit for equality. If I have to give up my half of my pay, that's fine, because now we're equal. So this is the way that equality works. It's not about how well or how fairly you treat people, because you could say it's fair to pay people more if they're bringing in a bigger audience. Another example some people may have seen is the tennis. The women's tennis said, why are we paid less as our prize money than the male tennis? And they tried to run the same argument. That's because the male game brings in much more in advertising than the female game, because women aren't watching the sports as much as men are watching the sports. And they said, well, we don't care. We just want equal pay because, otherwise it's sexism. So there are many examples of this, and this is how the legal system works based on comparison. So when you think, oh, it's about fairness, it isn't. It's actually to do with comparisons, which can be quite perverse. So in the Birmingham case that I gave the example of, dinner ladies, their work is serving the children lunch. They said, why are we paid less than the men who drive those trucks that go around the city collecting the garbage? And the city said, well, because it's not the same work. You're in a school serving lunch, and they're out lifting and carrying and clearing the city. But they said, we have no men serving lunch to compare with, and we have no women collecting garbage to compare with. So because we have no comparison, we're just going to have to compare the women serving dinner to the men collecting the garbage. This is how ridiculous the equal pay system has become, because the law is based on comparison. It's not based on fairness. And I want to show why this has marched through the law, the legal system, in the way that it has. It is based on a notion of what is called substantive equality. Not formal equality, but substantive equality. So what does substantive equality mean? It means something like real equality. So the people who've pushed this in the legal system are saying it's not enough to say formal equality. Everybody has an equal opportunity to show up anywhere and participate in anything. They said it has to be real. And how do we know whether we have real equality? Well, we just look around. And if we don't see an equal number of women, we say, well, the equality is not equal. If we look around and we don't see representatives of every race on earth, we say, okay, well, the equality is not real. We have formal equality, but not real equality. Many people have tried to say the law as it is framed only focuses on formal equality. Equal treatment, not equal experience of life. But here's the problem. When you have equal treatment, observers expect to see some sign of it. They have expectations for what they expect to see, and if their expectations are defeated, then they say that the law is being violated. And you see this in the jurisprudence as well, from judges saying, at least in the British context, saying the law has to mean something, otherwise what's the point of it? You can't have a law that says equal treatment and nothing happened. We expect to look around and see what has happened owing to this equal treatment. And so it's to give the law meaning in real practical cases that all these concepts have arisen. And as I have argued in the book that I was just showing you, I'm just going to quote from the book. I say, when read in light of substantive equality principles, it becomes clear that the legislation requires treating people as if they were equal when they are not. That is what you have to do. The women and men's game is not equal, but you have to treat it as if it were equal by paying them the same wage. And so we've had legal concepts like disparate impact, or indirect discrimination, as it's called in the European context. And this is a situation where you have a rule that's the same for everybody, but some people are experiencing it differently. And then that is said to be a violation of equal protection. We have positive action. Again, this is in the British context. It's called positive action, meaning you don't just say equality is good, you must take steps to promote equality. You are not allowed to discriminate positively, but you must show that you're taking positive steps. This is a legal obligation. It's not just policy. It is there in the law. It is there in European law as well. Harassment provisions, that is the law. If anybody says, I feel harassed, that is a legal obligation. And harassment could be things like people saying you're telling sexist jokes, you're telling racist jokes. that is a claim of harassment. So we're not just talking about policies when we say DEI, we are talking about legal obligations. So the law obliges people to treat everyone as if they were equal, to create equal opportunities for both the qualified and the unqualified. In the example of university admissions, you admit students who are qualified, and you also admit students who are not qualified. Why? Because you are to treat them as if they were equal. That is the way that the legal framework has unfolded. So I can give an example of admissions to university, to law schools in the United States. In the 1960s, when the civil rights movement just begun, many universities in the United States were already saying we want to see diversity. And so we're going to just admit pupils that will create that look of diversity. So when you look around, it looks very diverse. For this to become possible, they had to admit students who were not qualified. So in the Yale Law School in 1964, they had 7 students, black students, admitted who were qualified, but they wanted about 40 students. So the rest of the quota was filled by students who are not qualified. So you have a tiny minority of qualified students in a sea of unqualified students. And the results of this have been disastrous. Some of you may have seen a professor at Georgetown Law School who was overheard. This was during COVID when we all had to do classes on Zoom on the internet. And you might be heard by people you didn't know were listening. And she was heard saying, these black students, we all know they're not qualified. Everybody knows this. They fail all the courses, and then we're told we have to pass them because you can't just fail all the students or the university will be liable for racial discrimination. She said, everybody knows this. And then they fired her. But it is true that everybody does know this, and it's because of the legal obligation to fill the seats. So Clarence Thomas, the United States Supreme Court Justice, he said it's like bringing in the furniture. You look at the tables and you say, we need more seats, we need more chairs to fill in the space. He says they bring in black students in exactly that way. We need more black students, you need to bring some in. Whether they're qualified or not is deemed to be completely irrelevant. And that is why he called it a cruel farce. Why is it cruel? Think of those 7 black students at Yale who were qualified, who worked hard their whole life, only to find themselves in a sea of unqualified people. In fact, Yale is saying to them, we don't care the fact you're qualified, that was irrelevant. We admitted you because you're black. We don't care the fact. You personally may want to feel you're qualified, but the university doesn't care if you're qualified or not. And he found the same thing when he graduated from Yale, that he went to work in law firms who also didn't care. You're the black guy from Yale, that's what they care about. That's why he called it a cruel farce. And I think we heard this from the paper earlier about the same thing for women, making it in male-dominated fields who are told you're the female quota, nobody cares if you're qualified. In Norway, where for a long time they had quotas for women on boards of directors, I think Norway was the leader, but you have the same thing now in many European countries. I think in France as well, it's now the law. And in England, it's encouraged to have women on the boards of directors. But in Norway, when they started, they used to call these women the golden skirts, to imply that they're there because they're the skirts. We need skirts at the table, so you come and do the job, which is incredibly unfair because they were qualified for what they were doing and nobody cared. Now we may ask, if we do it properly, can we have equal opportunities in the law? Because some people think, well, it's all gone completely wrong with quotas and, measuring gaps, but how about if we do it properly and just think about it as equal opportunities? And I reject this idea as well. I draw here from the economist James Buchanan, who says you can't equalize opportunities in life. He says you cannot equalize the opportunities for people to win a game. You can't equalize, you can't have people at the starting point of a race where you say we all have an equal opportunity to win the race. You don't, because the opportunity of a player who is fit and strong is greater than the opportunity of a player who is weak. Their opportunity is not the same. And Buchanan says, here I quote, "Inequalities will remain. Opportunities will remain different for different persons because we are different. We can say, let's be fair in giving people chances. Let's be fair, let's make sure everybody's on the same starting line, but we can't say, let's make it equal. It is not equal. It is fair, but it is not equal." So how has equal outcomes ended up in the legal system? People say DEI is just policy, it's not in the law, but I want to show that it is in the law. Go back to the 1954 United States Supreme Court case of Brown and the Board of Education. Here already in 1954, long before DEI, we already see this language of inclusiveness, including people in a school. So the thing about the case of Brown and Board of Education, it was about racial segregation in schools, separate but equal. The schools were racially segregated, but they were equal, and the court says that is not sufficient. We don't just want equal schools, we want racial integration. The word equal doesn't say integrate races, but that's how the court understood it. They said a school can be great based on factors that you can't measure, just like the friends that you can make, the hobbies that you can participate in. So they said the only way to make sure we have equality is to make sure people are included in the same school. And they said true equality then requires inclusion in that sense. And that's what I'm trying to say. You look back through the case law and you can see that inclusiveness is already within the law. There's also diversity within the law, the idea that diversity is a legitimate goal for states to pursue, and that in order to ensure that there's equality, you must ensure that people, that educational opportunities are permitted to be diverse. So that's the problem. We see these concepts in the legal system. We also see it in the enforcement. If you take a body like the Equal Employment Opportunity Commission in the United States, they have to ensure that people are being treated equally. They have to go out into the workplace, go out into schools to make sure there is equality. What are they going to be looking for? They are not looking for abstract concepts. They're looking around to see, and they're asking people what their experience is. So you can't separate abstract notions of equality from what is happening on the ground. We also see judges talking about the purpose of the law. The purpose of the law being to redress historical injustice. We see this in a lot of the case law, and that's why people are treated differently when it comes to DEI. We have double standards. People who say they were historically disadvantaged being treated better than people who were not historically disadvantaged. Free speech is encroached upon in order to protect the historically disadvantaged, but when it comes to people who are said to be privileged, then we don't allow encroachments on free speech. And these are the kind of double standards that you see everywhere in the law. So even though we find economists like Thomas Sowell saying that we should distinguish opportunity from outcome, in practice, the law does not draw that distinction. So I want to say a little bit about attempts to ban DEI. Because some states in the United States, for example, Alabama, have banned DEI. The law in Alabama prohibits public entities, publicly funded entities, from maintaining diversity, equity, and inclusion offices. All the DEI offices had to be closed down, and all the staff had to be let go. And the universities and schools and any government offices are not allowed to sponsor DEI programs. And the Department of Justice is enforcing this to see if any DEI programs still exist, because they are now illegal. So I'm not just talking about Mr. Trump's executive orders. Those of you who follow Mr. Trump, I don't know if anyone here follows Mr. Trump. He issued a number of executive orders saying no more DEI. And those have been frozen by many judges who are very much against what he's doing. But I'm also talking here about the law that bans DEI. And these have been challenged on constitutional grounds and on civil rights grounds, with people saying you can't ban DEI because DEI is required by the Constitution. DEI is required by civil rights law. So the problem here is that although DEI was banned because it privileges some races at the expense of other races, that has been challenged by saying you cannot ban privileging some races above others because the law itself requires it. We are in what might be described as a constitutional crisis, with one side saying the Constitution requires DEI and the other side saying DEI violates the Constitution. Is diversity really our strength? I want to ask. Diversity is not our strength. Diversity is a Trojan horse. The minute you say diversity is our strength, you are opening the gates for the Marxist Trojan horse to come in. It is in the name of diversity that white people are excluded from jobs and higher education. It is in the name of diversity that government employees in the United Kingdom were forced to read a DEI training manual called The Psychosis of Whiteness. It said white people are psychotic, they're violent, they cannot be reasoned with, and they must be destroyed. This was in a DEI training, and all the black people are like, yes, yes, they're psychotic, they're psychotic. And the white people there were not happy with being destroyed. So they brought a lawsuit saying that this violated their rights to be treated equally, which the judge dismissed. In fact, he told them to stop being ridiculous. What do you mean complaining? He said, go and read. So this was it's a book called The Psychosis of Whiteness that had been made into a paper, The Psychosis of Whiteness. And the judge said, what are you complaining about? Just go and read the paper and think about it. Nobody has attacked you. Nobody has destroyed you. They're just getting you to think about whether you should be destroyed. So go away and stop complaining. This is the way that the courts are looking at this, and I think any reasonable person can see that this is not right. And this is why those who love liberty, freedom of contract, freedom of association, freedom of conscience and belief would urge that we should reject equality in all the forms under which it marches through the law. And I have a quote. I just want to finish with a quote from Ron Paul. He's talking about the Civil Rights Act of 1964, which is the American main equality legislation. He says the Civil Rights Act of 1964 gave the federal government unprecedented power over hiring, employee relations, customer service practices of every business in the country. And he says the result is a massive violation of the rights of private property, the freedom of contract, which are the bedrocks of a free society. DEI, equity, social justice is an existential threat to individual freedom. And what I want to suggest is there are no good threats to individual freedom and bad threats to individual freedom. So you should not compromise and say threats to individual freedom are acceptable as long as they don't go too far. Because I want to put it to you that any threat to individual freedom should be rejected. Thank you.